to the Leadership for Society series, People and Planet in the Information Era. Today, I'm joined by Cade Crawford, Director of the Technology for Liberty Program at the ACLU of Massachusetts, and Susie Alegre, legal data privacy expert and author of Freedom to Think, Protecting a Fundamental Human Right in the Digital Age. Thank you both for joining me.
Pleasure.
Happy to be here. Thanks.
Great. So, Cade, I want to start with you. You direct the Technology for Liberty program, and you helped launch the Press Pause on Face surveillance program. Can you describe those programs to us a little bit?
Sure. The Tech for Liberty program at the ACLU of Massachusetts works on a host of issues at the intersection of technology and civil rights and civil liberties. So we basically try to do two things. One is to update the law to reflect new technologies to ensure that we're not leaving our basic civil rights in the analog era. And the second thing that we do is we try to use technology to advance some of our other core civil rights and civil liberties goals. And we have a data science website towards that end, data.aclum.org, the Data for Justice Project, where we basically use data science to try to make convincing arguments in favor of some of our other law reform goals here in Massachusetts. One of the primary things that we've worked on for the past 10 or so years since the program was born in 2013 is trying to modernize state law to reflect new technologies with respect to privacy and surveillance. And so we do work in the courts as well as in the state legislature and in municipal governments throughout Massachusetts towards that end. The Press Pause on Face surveillance campaign was launched in 2019. The goals of the campaign were threefold. One, to modernize state law to reflect police use of facial recognition technology. Two, to pass a number of local prohibitions on government use of facial surveillance. And third, to educate the public and lawmakers about the threat that this technology poses unregulated in the hands of the government. And I think we've been pretty successful thus far. We haven't quite declared victory yet on all of those items, but we have passed initial regulations on police use of facial recognition technology in Massachusetts. We hope to strengthen those regulations by passing into law recommendations that were created by a special legislative commission that I served on last legislative session to tighten up those regulations and strengthen them in some key ways. We also passed 8 municipal bans on government use of facial recognition technology, including in Massachusetts' 4 largest cities, Boston, Cambridge, Springfield, and Worcester.
So I have a question. For you. Can I ask you a question here? How are police using this technology? So tell me how they're using it and why people should be concerned.
Well, I think that there are at least 3 different things that we're talking about when we talk about face surveillance technology. One is what I would actually call like image matching, and it's what, for the most part, constitutes the bulk of police use of facial recognition in the United States today. That is essentially using facial recognition algorithms to compare a probe image of an unknown person to a set of labeled images, for example, in a driver's license database, a mugshot database, to try to put a name to a face in a criminal investigation. So police across the country are doing that, and they have been doing it for quite some time. As part of our campaign in Massachusetts, we filed public records requests with every police department in the state, as well as with the state registry of motor vehicles, which maintains the state identification database and driver's license registry. And we learned that since 2006, as a matter of fact, the police in Massachusetts had been using the statewide driver's license database repository as a data set against which they were checking images using facial recognition technology in criminal investigations.
Isn't this a good thing? So tell me why this is not a good thing, right? So if there's somebody does something wrong, I don't know who they are, but I have their photo, right? I caught someone in the act of doing something, hypothetically. Why shouldn't I, as the police, or why shouldn't I, as a citizen, want the police to use this technology to find that person?
So I'm going to answer your question in a second, but first I'm going to finish what I was saying, which is that there are two other ways that the government can use facial recognition. One is in so-called emotion analysis. So that's, software that purports to be able to determine how someone is feeling based on the physical characteristics of their face. Are they lying? Are they happy? Et cetera, et cetera. And the third is using facial recognition algorithms to analyze video data. So this is what, for example, the Chinese government is doing in Xinjiang province, using facial recognition algorithms to automate the analysis of huge quantities of video data. And that is what we call face surveillance. So to answer your question, we believe at the ACLU of Massachusetts that there are actually responsible ways that police can use facial recognition technology to conduct what I first described as image matching, right? What you said, you have a picture of someone, you suspect that this person has committed a very serious crime like kidnapping or arson or murder or something, and the police simply want to know, who is this person, right? We believe that subject to very rigorous regulation, it is actually possible for the police to use that technology without unnecessarily or grossly violating people's civil rights and civil liberties, and it can be done responsibly. The other two ways of using facial recognition, though, for a variety of reasons, which I'd be happy to get into, we don't think it's really possible to regulate appropriately. And so we think, the kind of cost-benefit analysis, the harms that would be inflicted on people's basic civil rights and civil liberties, our right to be left alone, our right to, walk around a city or our community without being tracked everywhere we go, every minute of our lives by the government. Those harms outweigh the possible benefits that the technology could provide. And so we do believe that those uses ought to be prohibited permanently, but that, yes, this image matching piece can be regulated and can be regulated appropriately. So that's what we're trying to do in Massachusetts.
Got it. That's very helpful. Thank you. Susie, I want to kind of come to you and ask you about what you mean by freedom of thought. So and this is kind of going to, I think, related to Cade's point about some things being not the cost benefit analysis being such that they can't be used responsibly. And so if we think about that in terms of freedom of thought, help us understand your position here.
Yeah, no, absolutely. And I think the issue around emotion recognition technology that Cade's touched on has really been a key thing that I've been looking at from the perspective of the right to freedom of thought. Ideas around privacy have become much more current and much more familiar. So we kind of understand a bit what we mean when we're talking about privacy. And certainly from a European perspective, the way that privacy is developed in the digital age is quite complex and very nuanced. And as Cade was saying, there are ways of regulating. There are ways in which it might be proportionate to limit our right to private life. But what I've looked at is really how privacy works as a gateway right, if you like, to other rights. And the right that I started to focus on over the last 5 years or so was the right to freedom of thought, and looking at what that meant in international human rights law. And when I first started looking at it, I found very, very little real analysis, nothing like what you find jurisprudence around privacy, to say, well, what does it actually mean? It sounds like a very profound idea, but what does it mean legally? And essentially what we're talking about when we talk about the right to freedom of thought is sort of three planks. The first is the right to keep your thoughts private. So to keep what's going on inside your head to yourself. The second is the right not to have your thoughts manipulated. And the third is the right not to be penalized for your thoughts alone. When those rights relate to purely what's happening inside your head, so not what you're doing or what you're saying or how you're expressing your opinions, but simply what's going on inside your head, in international human rights law, those rights are what are known as absolute rights. So that's like the prohibition on torture. If something amounts to torture, you can never justify it. You can't justify it for security reasons or any other reason. The same goes for this right to freedom of thought inside your head. And as I say, that's not the same as the right to express what you're thinking or the right to act on what you're thinking, but simply what's going on inside your head. And the use of emotion recognition technology, particularly in the policing and security space, I think hits the first and second aspects in particular of that right. What emotion recognition technology says it does is understand what's going on inside your head, what you're thinking and feeling, what you're thinking of doing, not what you've sat down and written and made plans to do, but literally what's going on inside your head at a particular time. And to use that information then to penalize you for the inferences about what you're thinking of doing. So if you think about it, for example, in a sort of shoplifting context, where emotion recognition technology might be used to sense whether or not somebody's thinking about shoplifting, not whether they have stolen something, but whether they're thinking about it, and to take action before it happens. And that, I think, is the real concern about emotion recognition technology. It goes to the heart of what's going on inside our heads, if you like. It doesn't give us the opportunity either to explain ourselves, to act on what we're thinking. It doesn't give us an opportunity to push back. And I think it's important to bear in mind that the drafters of international human rights law, of the International Covenant on Civil and Political Rights, and the Universal Declaration on Human Rights, recognized that it wasn't just a problem of people actually knowing what you're thinking. It's about inferences about what you're thinking. That is just as dangerous, potentially. People making inferences and saying, this is what you're feeling, this is what you're thinking of doing. It doesn't matter whether or not they get you right. If you're then penalized, arrested, removed from a situation because of those inferences, that is a very serious violation, potentially, of an absolute human right. And that's why I think it's important. And essentially, we can't protect that right if we don't have privacy. And that's why I say privacy is, in some senses, a gateway right to protect other rights, which have different implications.
Got it. So, Susie, I'm curious about the second one, the one not to have your thoughts manipulated. That one seems the most, from my perspective, complicated, because in some sense, our thoughts are. You could argue our thoughts are being manipulated all the time. So, in the example you gave of shoplifting, so if someone puts up a sign that says, no shoplifting allowed, it's an attempt to manipulate your thoughts. So, I'm wondering where you draw the line. Like, how do we think about what is acceptable persuasion and what is unacceptable manipulation?
It is a complicated question, and it's one, because it's very much an area of law that hasn't really been developed, that was sort of ignored. So what you see in the jurisprudence or the commentary was often, well, of course, our right to freedom of thought is absolute, but no government can manipulate our thoughts anyway. No one can get inside our heads anyway, so we don't need to worry about it. So we haven't seen the law and where those lines lie developed in the way that we have around the right to privacy, for example. So it's still very much an area, a developing area. But the European Court of Human Rights did look at this question in relation to religion, for example, and said, there is a difference between preaching and brainwashing, if you like, in the religious context. And so that is the kind of line that you're looking at, I suppose, between legitimate influence and manipulation. And obviously, I'm an advocate. I've worked as well as a civil society advocate, as an advocate in courts. My job has been to influence and persuade people, and hopefully never to actually manipulate people. But what we see in the digital era that's changed quite significantly is the ability to target people individually based on their personal vulnerabilities, if you like. And so we saw there were reports in 2017 in Australia, for example, that claimed that Facebook was selling real-time information on young people's emotional states in order to target them with advertising. So effectively saying, this person's feeling a bit low, now would be a good time to sell them something they don't need to give their ego a bit of a boost, that kind of thing. Facebook said they weren't ever selling those services, but it was reported in 2017. And certainly, the programmatic advertising business is based on the idea that this can happen, that we can be identified as individuals online and have targeted advertising that will push our personal buttons. It's what the Cambridge Analytica scandal was about in an election context, was regardless of whether they actually could deliver on their promises, what they said they could do was identify people's personalities, identify their vulnerabilities, and use that information to then target messages at them which would affect their voting behavior. So that's what they said they could do. And as I say, I think regardless of whether or not they could deliver that, that kind of service really ought to be unlawful on the basis of it being an interference with our freedom of thought, both for trying to access what we're thinking and feeling, but also to directly manipulate us by getting behind our rational faculties. It's not the same as a billboard on the street with a political advert. It's something which is really designed for us not to notice, for us not to see, for us not to question on an individual basis. And I think that is an example where we're really looking at the way manipulation can happen in the digital sphere.
Yeah. So as a psychologist, I would just say the line seems a little blurry. So if you have TV ads, they're attempting to influence you in ways that you don't completely understand. Right. So I do take your point that the sophistication in advertising has increased because of the ability to target. So I'm wondering if that is the line. Is it the targeting, the specific targeting as a function of your current state, or is it just the ability to manipulate without your awareness?
I think it'll depend on the context is the sort of legal answer, I suppose. We'll see on a case by case basis, but I think absolutely this ability to identify psychological vulnerabilities and use them to target people and exploit those vulnerabilities in real time is what I think is very different now in the digital sphere compared to historical examples of advertising. But particularly in the advertising industry, there are big questions of, well, where is this line? What is legitimate, lawful advertising and what amounts to propaganda in the political sphere that might be considered to be unlawful, and what amounts to manipulation of individuals, particularly vulnerable individuals. And I think that's one of the reasons we see that targeted advertising to children in particular is being contested, because people we all like to think that we're immune to manipulation, that of course we're far too clever to be tricked by these things. I mean, I think possibly thinking you're so clever is a potential vulnerability for the targeting itself. But that aside, we all recognize that children are different, that children do need protecting from the outer world as they grow, and particularly have minds that are open to nefarious manipulation, if you like. And so I think that's why you see a lot of the discussions around advertising are focused either on children or on this political side of the equation. And going back, I think, to the emotional recognition technology or the facial recognition technology, one of the areas I think is really dangerous in this space is researchers who are claiming that they can tell your political opinions based on a photograph. So a still photograph of any one of us, in theory, can be run through an AI and somebody can make inferences about which way we vote. And if you think about that sort of in a democratic context, what that then means for you potentially being singled out, made to jump through extra hoops to get to the voting booth because your face looks like you're going to vote the wrong way. I think that raises really, really big questions, again, going back to the facial recognition issues.
So on that, I'd like to put this back to Kade and then come back to you, Susie. How do we think about the interplay between private and public in terms of surveillance? So Kade, you really focused on the state use, in particular the police, of surveillance, and Susie focused more on the private side. So Kade, I wonder how you think about the private-public divide in terms of the use of these technologies.
Can you say a little bit more about what you mean?
I mean, so for example, are you more comfortable with the private use of these technologies than with the governmental use of them?
Oh, okay.
When you think about regulation, because your focus has been primarily the regulation of state use. Are you also concerned about the regulation of private use?
Very concerned, yes. We started our work on facial recognition here in Massachusetts focused on the government, primarily because Jeff Bezos, Amazon, Google, Microsoft, they're powerful companies, but at least at the moment, they can't deprive me of my liberty and, arrest me and lock me up. Those companies also don't have the ability to use lethal force lawfully, right? So the government still retains some unique powers that we believe, make issues like government surveillance rise to a really significant level of concern. So we decided to tackle police use of the technology first. But we do support in Massachusetts laws, bills like the law in Illinois on facial recognition, the Biometric Information Privacy Act, BIPA, which is the nation's strongest legal protection people have against corporate collection and use of their biometric data. Basically, BIPA just says that before companies can collect a person's biometric information, they need that person's affirmative opt-in consent. And, for most people, this consent will not be freely given. This consent will not be given at all. I don't think most people want Walgreens or, as we learned a couple of weeks ago, the owners of Madison Square Garden or anyone else collecting their biometric data to be used for surveillance or marketing purposes. So we do intend to establish a law like that in Massachusetts. We just, wanted to start with the government because of the government's unique powers.
I think as well that the lines are very blurred these days. It's not how it was even 20 years ago. What we see is that you'll land up with new tools being developed and designed based on a sort of private sector approach and gathering information, for either that's widely available on the internet or being collected for private purposes. And that then training tools that are going to be used in the security sector. And so that line, although, absolutely the powers of the public sector are much harsher, but what we're seeing now as well is the ability of the public sector to bypass their own regulation by using information that's been bought or provided by the private sector. So we suddenly find that the private sector is creating a loophole, if you like, for then the use of these more coercive powers in the public sector.
Well, we've certainly tried to account for that in our legislative work here in Massachusetts. And, if I could snap my fingers and make laws, unquestionably, we would have done all of this at once, right? But that's not the way any of this works. And, lawmakers have a lot of other issues on their plates. They're dealing with housing and transportation and climate and all the rest. So we want to keep things as simple as possible for legislators and for our communities that we're trying to organize in support of legislation. And, as a political matter, it's not a good idea to try to wage a political fight against the police and the largest tech companies in the world at the same time. So we decided to split those up and try to tackle them independently so that, we'd have a better chance of success. But certainly if I were king, I would deal with all of these problems immediately.
Can I go to a different topic that's related, I think, Kade, to the face surveillance and also people's willingness to give away biometric information. So DNA. So recently, there's been a spate of articles about cold cases being solved, murder cases, very high-profile murder cases being solved using DNA. And basically, the way they've done it is because people have freely given their DNA to a number of companies. And based on if someone, a relative of mine, somewhat far removed, gives their DNA, then they can kind of find out who I am. And they're using that to trace back to killers. Help me think about how we should feel about this. I mean, this is a complicated issue. One, some serious murder cases have been solved. So murders have been taken off the street. So should police be able to use these techniques? So let me start with you, Kate. What do you think about that?
Well, I think first, people have been captured by marketing. 23andMe and Ancestry.com have had really successful marketing campaigns that have convinced people who, maybe are a little bit narcissistic or interested in learning about, their origins, their families, to hand over what is probably the most sensitive information that we possess about ourselves, our DNA. I think that speaks to a lack of public awareness about what DNA can unlock, not just about, as you said, Brian, me, but about everyone who's related to me by blood. So I would love to see that change. I would love to see, more public education about, how much companies and governments can learn about a person or a family. It's not just, whether or not someone's information is tied to a criminal case, it's health information, right? I think if people were more aware of that, they would be a lot less willing to hand over that sensitive information to an industry that's entirely unregulated. And, to answer your question, I think the answer is that the government needs to step in. Legislatures need to step in and apply some very strict rules, not only governing how the police can access that information, but also governing how companies can share and use the data that they're harvesting from willing subjects who send it in to learn about their families and things. So for police investigations, there ought to be a warrant requirement at minimum for the police to be able to access information held by those types of, ancestry or genetic sequencing companies.
No, I agree completely. I think one of the fascinating things is the kind of question about what do you do about your family member who's basically handed away your DNA? And that kind of question on consent is a really huge question. And it's now also a global question. We're living very much in a globalized world where, I don't know if my cousin on the other side of the world has handed in their DNA, including elements of my own. And I think also, as Cade was saying, it's not just about criminal justice. That's almost the big sell, isn't it? We've solved cold cases. We've brought killers to justice. Therefore, it's a justification for having everybody's DNA on record. But not knowing what the consequences might be, if it reveals sensitive health information, when it does reveal sensitive health information, how will that be used? Will that then mean you won't get access to healthcare? Will it mean you might be excluded from certain jobs? What will it mean for your children? The consequences are really endless. And as Cade says, it's very much an unregulated area of industry with really global repercussions, and something that we need to be thinking about very urgently. And it goes back as well to the kind of question of profiling. If you've got your online profile and your DNA profile, there are almost no limits to what can be identified about you, the inferences that can be made about who you are, how you think, and what your opinions might be.
Mm-hmm. So let me go to another area of privacy that is maybe more contentious in some ways. So after Roe v. Wade was overturned in the United States, there was a lot of concern about the data that people have out there being accessed to determine whether or not women were getting abortions, and then possibly charging them criminally. And the issue there is that there's so much information that we give away just as being members of kind of modern society, the way we engage. I mean, our phones are on giving our location data. There's just so much information where we're not even thinking about it as like sending something in to 23andMe. We're just going about our daily lives. Like, how should we manage that? Like, what do you tell someone who's now concerned that if they want an abortion, someone could find out? How do they engage with the modern world now?
Leave your phone at home is a first starting point. I think it's a really challenging issue, not only for that. Obviously that really, I think, drew it to attention, particularly in the US. That your location data tells a huge amount about you, particularly when it's triangulated, with other people who you might be hanging around with. And again, it's not only about whether or not you've actually accessed abortion services. It may be whether you're planning to, whether you've been thinking about it. And again, this kind of question about who's controlling the data, what it can be used for. One of the things that I think is really important in terms of data is putting down very clear regulations about what data can never be used for, but also just what data can be collected and saved at all. And all of this location data is phenomenally sensitive. There was an attempt at a lawsuit here in the UK, which failed in the end on technicality, but which was a class action about Google effectively using a backdoor into Apple devices for location data to then target people with advertising. And again, it was about the kind of the sensitive nature of knowing what you're thinking based on where you are, how you're behaving, and to use that to try and manipulate you without you knowing that your phone is effectively, flagging your vulnerabilities, knowing that you're walking past a donut store and that you're feeling a bit down this morning, and therefore, hey, wouldn't you really love a donut to perk you up? And it's a similar kind of thing. It can be used in so many ways, whether it is about something as sensitive as abortion with potential criminal consequences. But in other countries and other contexts, it could be about sexual orientation, for example, that can be revealed. And there was a case in the US a couple of years ago with a Catholic priest being outed by investigative journalists based on the data that was just able to be bought on the open market about him, that identified him as somebody, who was apparently gay. So, I think that flags as well that it goes way beyond abortion to pretty much anything in our lives, which whether it's criminal or whether it's something that for other reasons we don't want people to know about what we're thinking and what the consequences might be.
So, Kade, is the genie out of the bottle? The way we live our lives now, it's hard to imagine that we don't leave a trail of data everywhere we go, that people are picking up and examining for all sorts of reasons. So is it possible to regulate this away?
Of course. The only genie that's out of the bottle, from my perspective, that is an urgent crisis right now is, the amount of CO2 emissions that we've spewed into the atmosphere, setting off chain reactions that, we can't unwind. We can stop, spewing carbon and try to limit the damage, but those are natural processes that human beings can't control that we've already kind of unleashed. This is totally different. This is just decisions made by human beings every day about, what kinds of technologies to develop, what kinds of rules will be in place to govern the data that those technologies produce, and what kinds of laws we'll have and regulatory systems we'll have to enforce those laws. So absolutely not. It's certainly these are big challenges, no question. There are enormous, very powerful companies, based very close to where you are at Stanford, that are going to try their damnedest, spend millions of dollars to stop meaningful privacy regulations from coming into effect, from being appropriately enforced. But, if we still live in a democracy where, one person has one vote and we can lobby our representatives to pass laws that benefit the public interest, not private corporations, then there's no question in my mind that we can completely change, the future trajectory of digital privacy in the United States and frankly around the world. It is simply a political matter. It is not technological. It is not, it's not a technological problem. It's purely about how much political power we can build and exercise and wield in state capitals and in Congress. And I believe we can.
So, okay. I absolutely agree. That it can go. And I think one of the big questions is why this data is valuable. And so if you start to regulate to say, actually, you can't use it, for example, for targeted advertising, then it won't be valuable and it won't be collected in the same way. And you will totally shift the trajectory of innovation in technology into a different area. This is very new. It's really only, 10, 15 years that this massive boom in data collection has happened, in large part because of the boom in targeted advertising, which is then, put it on this direction, which then gets picked up for, isn't this useful for security? Isn't this useful for health? Whatever. But it's come from that. And I think, one of the things that I think is really exciting for the start of this year is the European Data Protection Board finding that Facebook, Instagram, Meta's business model of personalized advertising is unlawful under EU law. And, if that stands, it effectively changes the whole basis of social media as we know it, which in turn changes the impetus of data collection and where the money is. And I think that we will see big changes in the next 5 years because it will also then be in businesses' interests. People will be thinking about new ways to develop technology that don't involve this mass collection of data potentially.
So I guess what I would say is I think it's the technology and political will, but I'm also interested in how we think about human nature. So part of the reason that it's happened this way, I'd argue, is because it's created what people experience as convenience. We could obviously have arguments about whether or not that's true or whether it's worth the trade-off, but it's certainly not debatable that people are giving away their data, and it's that uses can be nefarious. Not necessarily are, but certainly can be. So I wonder, when you take into account what we've become accustomed to, the way organizations engage with us, the expectation of convenience, what hopes do you have for the future, and what fears do you currently have?
I'm not particularly concerned about that. I mean, people, just as a good example, right? People download apps like Angry Birds or Candy Crush or something, and I don't want to get sued by any of these companies. So I'm not saying that they do this, but, say you download a free app on your phone, and in exchange for you downloading and using that app, the company that develops the app has installed a software development kit and SDK on your phone that harvests your location data, and they sell that information to a number of data brokers, right? People are not aware that this is happening. It does not say when you download the app on your phone in a very clear, easy to read and understand pop-up box, we will be taking your location information every 30 seconds and selling it to 500 different companies on the internet. Do you wish to proceed? Right? It does not say that. It says nothing like that. If there's any indication anywhere that this is happening, it's buried in a very long, complex document written in legalese that most people never look at, and if they did, couldn't understand. So, do people want to download free apps on their phone? Sure. Would people be okay in a world in which you could not download that free app on your phone? It maybe costs 99 cents, or, you just couldn't engage with those kinds of like games on the internet. Yes, I think people would be absolutely fine in that kind of a world. There are some applications that we have come to rely on. Google Maps is a good example of an app that I think most people have on their phone and that many people use daily, if not multiple times a day, to help them get around, cities and their communities. I think what Susie said is really apt. If we successfully go down the road of, figuring out ways to put meaningful constraints on companies so that they have to minimize the amount of data that they collect about us, and then they can't turn around and sell that information on the open market, certainly without our consent, and in some cases maybe never, there are going to be business people who come up with new ways of making money, right? If you read Shoshana Zuboff's book on surveillance capitalism, you'll read the story of how the folks at Google, the initial founders, eventually just, figured out how they were going to make money off of all of the information that they had produced. There will be other people who, come up with bright ideas about how to pay, tech workers to produce the kinds of tools that many of us rely on. It may be a subscription model, right? I think a lot of people would pay $5 a month to use Google Maps in exchange for, knowing that their information is not going to be exposed, that they're not going to, for example, be discovered as gay, if they're a Catholic priest and fired from their job, or, have their boss find out that they have a very serious medical condition that they didn't want to disclose at work, etc. I think that human creativity needs a little bit of a push here, and that the tech industry in particular needs some inspiration to find other ways to make money. And I don't believe that as technology users, we are going to be forced to make a decision between, using technologies like Google Maps that really do provide a lot of value in people's lives, and handing over a trove of our personal information that we then completely lose control over, and can suffer, pretty serious consequences for as individuals as a result.
All right, so Susie, I'm going to give you the last word briefly because we only have a couple of minutes left. What are your hopes and fears for the future?
My hope for the future is precisely that. I think humanity is adaptable. I think we've been sold this idea that this is all so huge and such a massive revolution that there's nothing we can do about it. I completely disagree with that. I think change is starting to happen. And actually, Tim Cook at his Stanford address a couple of years ago pointed out that in the current environment, Silicon Valley would never have got off the ground because everyone would have been so distracted on whatever app it was. And everyone would have been concerned that everything that they were doing online was being monitored and that would have a chilling effect on innovation. So I think ultimately it's in everyone's interests, including the tech sector, to find new ways to innovate that protect our ability as humans to be creative. I suppose my fear is that we need to make sure that whatever comes next, right at the front end, we're thinking about the human rights implications of it. So we're thinking about, what's the worst that could happen when you start developing new directions for technological innovation, to make sure that we're thinking these things through and making the future that we really want.
Great. Well, thank you both. I really appreciate your time and also the thought you're putting into the work you're doing. These are really big issues, and they require the kind of thought that you all are bringing to bear on them. So thank you.
Thank you for having us.
Thank you very much.
Our next conversation will take place on January 30th at 6:30 Pacific time, and we'll focus on monopolies in the information era. I'll be joined by Congressman Ken Buck, member of the House Judiciary Subcommittee on Antitrust. Thank you all so much.